Hi, everyone. Welcome to Morgan & Morgan Employee Family Medical Leave Act webinar. Today, we're going to talk about what that actually means and how it affects your employment, and how to ask for it, and how to use it. My name is Anthony Bullock, and I'm an employment attorney with Morgan & Morgan. I'm here with my colleague, Paul. Paul, please introduce yourself.
Thanks, Anthony. Hi, I'm Paul Boutros, and I work with Anthony in Morgan & Morgan's Employee Rights Group. In the Employee Rights Group, we handle all matter of employment issues regarding wrongful termination, harassment, discrimination, etc. Things that you would generally think of impacting you in your day-to-day while working for your employer. In our fight for employee rights, we often find that people don't know about FMLA or the Family and Medical Leave Act. And throughout this webinar, we're going to address all your questions regarding these issues. So including how to know if your loved one is affected, what your rights are, and what to do if you're denied leave.
First, let's address the phrase itself. Today, we're going to keep it simple. The Family Medical Leave Act allows up to 12 weeks of unpaid leave in order to address personal and family serious medical situations, and up to 16 weeks of leave for family members who are current military service members. You get all of that without the risk of losing your job.
And while the FMLA is often thought of in reference to a parent caring for an ill child, there are a lot of other situations where the FMLA leave is available to you as a worker. It's called family medical leave for a reason, and it's applicable if you get sick or if you're caring for a spouse or a parent who also has a serious medical condition. So you're also eligible if the child was placed in your home or you're caring for a newborn, and this also includes adoption or foster children as well.
So those are the situations where FMLA may be available to you. But who's eligible? For your employer to be covered, they must employ at least 50 employees within a 75-mile radius. And to be an eligible employee, you must have worked for your employer for at least 12 months and worked at least 1,250 hours in the last 12 months.
So for example, let's say that you're an office administrator and you've been working full-time for 2 years for your employer. This company has over 100 employees. Suddenly, your spouse comes down with a serious medical condition and you need to take care of them. So you're within the eligibility because you've worked for them longer than 12 months and you've got more than 1,250 hours of actual time that you've put in. So at that point, you should be able to take 12 weeks of unpaid leave to care for them.
Exactly. And when you do employ FMLA, it's important to make sure that you do so according to the law, so your leave can't be denied. If you need to use FMLA and it's foreseeable, you must notify your employer at least 30 days in advance. That's if a situation is expected, like postnatal care or post-surgery care. The law recognizes, however, that in certain circumstances, you won't be able to give your employer 30 days advance notice. In those situations, you're required to give your employer notice as soon as practicable. Your employer may require that you submit medical certification of your need for family medical leave. If so, you're required to provide it. Based on the medical information and circumstances, your employer will determine if you're eligible to use FMLA.
What if you don't need to take 12 weeks at one time, take all of your leave at once? So you may need what's called intermittent FMLA leave. So if you're taking intermittent FMLA leave, employees are allowed to take leave in different blocks of time for the specific issue that you're dealing with. And it also has to be tied to an FMLA approved medical condition. So if you do take intermittent leave, you can take intermittent leave in incremental blocks of as small as 1 hour.
Indeed. And we've already said that FMLA is unpaid. However, any health benefits your employer provides are still in effect when you're on leave. And also, FMLA protects you from retaliation during your leave and when you return. According to FMLA, you must be returned to the same or an equivalent role after returning from your leave. And your employer cannot fire you or discriminate or retaliate against you in any way for using your FMLA benefits.
And if you've been denied leave for any of these issues, you've been retaliated against for taking leave, or if you feel that your leave is being denied and you're not being treated lawfully, we're here to hold your employer accountable, and we want to hold your employer accountable. It's essential both for setting precedent to make sure that your employer isn't basically trying to scare your coworkers into not asking for FMLA, and also helping the entire workforce know that FMLA violations are serious, and you don't have to just take whatever your employer is saying or doing to you in that regard. So, sorry, Anthony.
So sometimes I just want to remind folks that, sometimes people do not contact attorneys because they are worried about the fees or the cost. But the law factors that in. Because the law protects you from retaliation, and because we at Morgan & Morgan don't charge any fees unless you win, there's no cost to you to contact an attorney in this situation. And generally, there's no cost to litigate your case in the FMLA matter. So please contact us.
Now we're going to have a question and answer. So if anyone has any questions, feel free to submit them, and you can unmute your mic or use the chat system.
So any incoming questions?
I'm not seeing any.
Okay, well, thanks so much for watching. Please share this with anyone you like and anyone you think that may benefit from it. If you think your employee rights are being violated, you can give us a call at 888-506-5405. Again, that number, 888-506-5405. Morgan & Morgan's here for you. Have a great day.